Hello guys, welcome back. Today I will be continuing with what we left in the previous lecture, okay? And I have to begin from unlawful agreements. Previously we saw consent is important. The person whose consent was not free while making the contract, then the contract is said to be voidable on part of that person. Then capacity to contract also we saw. Now we come on to unlawful agreements. I hope it's pretty much visible and it's clear. If object of agreement is to perform an unlawful act, contract is unenforceable. Object should not be illegal, immoral, or opposed to public policy. If you remember, in the beginning of the lecture, of the beginning of this chapter or so, I have told you that if I am giving a certain amount of money in exchange of a high rank job or in exchange of any job, I am paying money, that I am paying you rupees 10 lakhs and you provide me this or that job. So this is illegal and it is also opposed to public policy, right? I cannot give money and buy a job. I can qualify for a job by giving examinations or whatever the qualification norms are, but I cannot purchase a job. Okay, so similarly, if any contract wherein there is an unlawful act to be performed, then the contract becomes unenforceable, means it cannot be enforced, and that contract is void. Okay, A enters into an agreement with B to share profits by giving false assurance to public to get them a job in Singapore. So now A and B are entering into an agreement wherein they will be giving false assurance to the public that they will be granted jobs in Singapore. Agreement involves cheating, which is fraudulent act. Agreement is unlawful and hence void. As I told you, these agreements which are having unlawful object, they are said to be void because they cannot be enforced. So doing cheating and giving false assurance that I will be giving you job in Singapore, you pay me this much amount of money and in exchange of it you will get a job in Singapore, so that is cheating, because in actually I'm not going to do that. Even if I'm going to do that, that is also opposed to public policy. But if I'm giving false assurance, that means I am cheating or I am doing a fraud, so that is also unlawful and hence the whole agreement becomes void. As per the Indian Contract Act, agreements entered into which are against public policy are said to have an unlawful object and hence are unlawful agreements, making them unenforceable. So the contracts which are against public policy, they are also said to be an unlawful object contract, and so they also cannot be enforced. A agrees to give rupees 1000 to B as a penalty if minor daughter is not given to A in marriage. This agreement is opposed to public policy and not enforceable. So what is happening in this illustration? A person A is giving rupees 1000 as a penalty to B if the minor daughter of B is not given to A. That means minor daughter की marriage हम नहीं कर सकते. We cannot marry a minor, right? Whether it is a boy or is a girl. So A is making an agreement to B that you give me your minor daughter in exchange of marriage, which is not possible legally otherwise, and if you are not gonna give me, then you have to pay a penalty of rupees 1000. So this is unlawful also, because we cannot marry a minor girl or a boy, right? Minor is less than 18 years of age. They cannot marry. So this is also opposed to public policy and also against the law. As per Indian Contract Act, agreements entered into by way of wager are not enforceable. Now next is wager. ठीक है. If there is a wager contract or a wagering contract, then also agreement is unenforceable and void. Wager is a contract where one person promises to pay other money on happening of an uncertain future event, and other person promises to pay on non-happening of event. So basically you say it in Hindi, bet. ठीक है, जिसको bet कहते हैं या कहते हैं जुआ लगा रहे हैं हम, कि इफ़ कहते हैं ना सट्टा लगाना या जुआ लगाना. If a particular team X wins, then person A will pay rupees 100 or whatever the amount is. If a particular team Y wins the match, then person B will pay rupees 100. So A is paying for happening of an event that is winning of X, and B will be paying for not happening of the event that is winning of X, because B will be paying for winning of Y, and obviously in a match only one team wins, right? I'm not talking about a tie or breakup situation. I'm talking about a win and lose situation wherein only one team wins generally, right? So in that, A is paying for the happening of the event which is winning of X, and B is paying for non-happening of event that is losing of X. Non-happening is obviously the opposite of the event which is gonna happen. So that is a bet or jua, or you can say now another term for it is wager. So wager is like a bet, okay? And obviously if the match is yet to happen, that means it's future, and we cannot predict future, so it's also uncertain future event, okay? So uncertain future event, one person promises to pay for the happening of it and another for non-happening of it. There is a reciprocal promise. Wager is like a bet where happening is the condition on which the promise depends. Obviously, like see the example that I gave you just now, the same example is given. Honestly, I had not read it. I am taking these lectures for the first time, so I haven't read what the book says, and by knowledge I have just give you that example, which the same example by coincidence is given in the book itself also. So illustration is, A agrees to give rupees 1000 to B if India wins the match on 24th August. B agrees to pay A the same amount if India does not win the match. Agreement is a wager and it is void. So since wager is unenforceable, so it is a void agreement, okay? And what is this happening of uncertain event is the condition on which that agreement or the promise depends, because the whole wager depends upon that whether India will win the match or not. And since it's a future event, we cannot predict future, so it is said to be an uncertain future event. Contingent contract. People get confused between what is a contingent contract and wager. That's why a difference table is also put up here. Since in wager also there is a condition collateral to the contract, depending upon which the contract will or will not take place, okay? And contingent contract is also a conditional contract wherein you make the agreement on happening or not happening of an event, okay? So the same logic, little bit basic logic is same, but then too there lies a major difference. That's why contingent contracts are valid, okay? Contingent contracts in some cases are valid. Contingent contract, also called conditional contract, contract to do something or not to do something on happening or non-happening of an event, which is collateral to the contract, okay? As I told you, it is also based upon happening or non-happening of the event, and that event is very important, or it is a basic or important condition for the contract to take place. Contingent contracts cannot be enforced until uncertain future event happens. So contingent contracts cannot be enforced till the time that future becomes present. That means whichever event, like I had promised something on 24th December, and the event on basis of which I had made the promise is yet to take place on 26th of December. So this is future. For now, for 24th of December, this is future. So till this future becomes present, that means till the day I come on to this 24th of December and that future event takes place. Once it has taken place, it will become present. So till the time this future event becomes present, this contract cannot be enforced, and wagers are enforced at the time being only when they are made. That's why they may be void. If uncertain future event becomes impossible, contingent contracts become void, because those event was the only condition upon which the contract was based, and now if the event is only impossible to take place, then obviously the contract will become void. Like try to understand, if I am making a contract for marrying a person, okay, that you will, like, not something immoral, I'm giving you an example which is completely as per the norms of society. If I am contracting with B that you like, suppose this is a father and son duo, okay, and father is saying to son that I will allow you to marry your lover C, lover of B, okay, C is lover of B. So father is saying to son that, listen to the situation very carefully, I will allow you to marry your lover if you quit smoking, okay, if you quit smoking, and your wedding will take place on next month 24th, your wedding will take place, but for that you have to quit smoking first. Now what happens is, before this 24 next month arrives, C expires. Have you understood? C dies out of an heart attack or whatever. Now what was the condition? That you will be marrying C, and for that I am making you a contract, that's quit smoking. So that condition which was collateral of marrying, वेडिंग के लिए ही तो बी भी अग्री हुआ और ए भी अग्री हुआ. ए ने मांगा कि तुम स्मोकिंग क्विट कर दो और बी की मर्जी थी कि हाँ मुझे शादी करने को मिल जाएगा. सो शादी करना वॉज द मेन कोलैटरल इवेंट, and if the person to whom the marriage was to take place, she has died, then that event has become impossible indirectly, right? So now this event has become impossible, so this contract is void, because if person is dead, then you cannot marry a dead person, right? Now illustration, A agrees to sell his farmland to B if he wins the case involving his farmland. Now let's suppose that a case was pending in the court, and regarding that suit only, A says that I will sell you the farmland if you win the case. This is a case of contingent contract because performance is based on happening of an uncertain event. Uncertain future event is winning the case. Obviously, now let's see what's the difference between a wager and a contingent contract. And please remember, this is very important, a minute thin line but very important. Wager is an invalid contract, it is void, and contingent contracts are valid. Wager, there is always a reciprocal promise. Reciprocal promise means win and lose situation is always there. One person has to always win and the other has to lose always, because if the event happens, then the person who has asked for the money for winning, then he will get the money, right? जैसा कि मैंने एग्जांपल दिया था, A and B, for A has promised to give ₹100 if X team wins the match. So A has promised for winning, for the situation of winning, so he is bound to get ₹100 and B is bound to lose ₹100. Or if vice versa happens, then A is bound to lose ₹100 and B is bound to gain ₹100. So one person or one party to the contract is bound to win another party is bound to lose something or some amount whatsoever of the bet is there, right? So a win and lose situation is there for one party. One party is bound to lose and one party is bound to win. So a win and lose situation, that's why it is said reciprocal promise. Contingent contract, no such reciprocal promise is there. Third parties do not have interest. Only the two parties who are involved in the wager, they are only interested in the amount of money that are involved. Okay? Third parties may have an interest. Wager is contingent in nature. Why? Because they are also conditional, they are also based on an uncertain event, and contingent are also based on an uncertain event. So you can say contingent is the big circle and wager is a small circle. Okay, vice versa, if this is not true, that means contingent contracts are never wagering, but wager can be contingent. Now, discharge of contract means to allow it to happen, okay, to perform the contract. Now we have seen that what were the essential conditions for the contract to take place. Now how to perform it, how to discharge the liabilities or the obligations which are concerned with the two parties who are in the contract. Mutual obligations of parties are created in a contract. When mutual obligations are fulfilled, contract comes to an end. See, what happens if I had promised that I will sell you the land, okay, like I'm going back to the transfer property law. I had promised to give my land to A for rupees 10 lakh, and B has finally bought the land. All the transfer and registration papers, the property papers, the title, all those documents are also transferred by A to B. So now everything is finalized, everything is over. The contract for which this transfer was going on, that all procedure is over. That means the obligation, the purpose, and the performance is done. So now this contract will become obsolete, means it will come to an end. हमारे बीच में ये कॉन्ट्रैक्ट हुआ था, हमने उसका हिसाब से सारा काम कर लिया. So now the contract is ended, and that means it is discharged. In other words, discharge means termination of contractual relationships, relations of the parties to contract. Like it is said, no, discharge means I am terminating the treatment. Like hospital, we say na, discharge कब कर रहे हैं. That means when are you leaving the patient. So discharge over here also means to leave, to terminate the obligations which were due to the over the parties as per the contract terms. Discharge of a contract may be done by the following ways: discharge by performance, agreement or consent, impossibility, lapse of time, operation of law, breach of contract. All these we will be seeing in a few minutes, one by one. First one is discharge by performance. When parties to a contract perform their obligations and fulfill their promises, the contract gets discharged by performance. When parties are performing, when parties are doing what they ought to as per the contract, then it is said that contract gets discharged by performance. Example, an offer to sell his dining set to B for rupees 10,000. B pays rupees 10,000 to A, and A delivers his dining set to B. Now what has happened? The obligation by the two parties are done. B's obligation was to pay the amount, that is rupees 10,000, and A's obligation was to deliver the dining set. So both have done their works, both have discharged their duties that were due as per the contract over them. So that means by performance they have terminated the contract. Discharge by agreement, novation, a new contract. See, wherever this novation comes, that means something new. So novation means a new contract, wherein the old contract is substituted by a new contract. So that old contract has no value now. Whatever terms or conditions, good or bad as compared to the older one, they are also obsolete now, and whatever are there in the new contract, that will only be considered. Recession, certain terms of or all terms are cancelled. Okay, if you cancel all the terms of some certain terms, or all the terms of the old contract, then it is that by recession we have terminated the contract. Alteration means to modify something, to put a little bit change in the contract, and the terms of contract are modified or altered with mutual consent of parties. Means both the parties to the contract should have their consents, that okay, I also agree to change this or that terms of the contract, then it will be that by alteration we have put a little bit of change. Remission acceptance is made to a promise but not on complete terms of the promise, but to a lesser fulfillment of promise. Means I have accepted a promise that I will not be able to comply with all the terms of the promise, but I will be fulfilling a lesser part. Waiver, parties to a contract abandon their mutual rights, means they waive off, वो कैंसिल कर देते हैं उनके राइट्स या उनकी ड्यूटीज़ को, दोनों पार्टीज कैंसिल कर देती हैं. सो दैट इज़ वेव ऑफ करना, वेवर. Merger, certain terms of a contract or all terms are merged into another contract with the consent of the parties. So merger is when they are merging certain or all terms of the contract with another one, and both the parties are having the consent to it. So remember, while doing alteration or while doing a merger, mutual consent of the parties is important. And then you need to remember these 6 terms which are given. Okay, what all these terms mean, you have to remember. Illustration: A enters into an agreement with B for buying certain machine parts for the project. Before agreement ends, A and B change certain terms and include those terms in the agreement. This is a case of discharge by agreement. Obviously, they are agreeing by mutual consent that we will be changing such terms of the contract. Next is discharge by impossibility of performance. Performance of a contract can become impossible with or without knowledge of parties to contract. It can become impossible subsequently after the parties have entered into a contract. Means after the contract has taken place, after they have entered into the contract, it may happen that there is an event which renders the happening of the performance or the contract to be impossible. As I gave you the example of that marriage just now, same thing. It can happen by supervening impossibility. Supervening impossibility takes place by the following: destruction of subject matter. I want to sell a piece of land, but that land in midnight is burned by fire, by any natural disaster, earthquake occurs, and that land is destroyed. So I have no control over it, and now the land which was the collateral for that agreement, that land is not there. So the subject matter of the contract is destructed. So the event has become impossible by itself. Death, as I told you, death का example था वो. Incapacity means at the time of agreement person was sound, and now the person has become unsound, and now he is not capable of fulfilling the obligations of the contract, or now it is revealed that the person with whom I had entered into a contract was a minor, and so the contract has become not enforceable. So any such thing can happen. Non-existence of state of things having an effect directly or indirectly on contract. Non-existence, I told you 2 examples right now: the house which I want to sell, and death of the person related to wedding. Outbreak of war. Now this is a very good example. Now if I am engaged in a business sort of relation with the person or company of another country, it do happen, right? Multinational companies do invest in various other parts of the world. They invest globally, and their franchisee chains or their malls and showrooms, their outlets are spread in whole of the world. So if it happens that there is a war between a country, like I say, there is a war between a country A, let's say, I'm not naming any country. There is a country A and there is country India. Okay, country A has invested in our country, but later on, after 1 or 2 years or after some period of time, there is a war between country A and India. So now what will happen? As soon as the war begins, obviously the one with which you are engaged in a war, that person becomes an enemy, right? And you're not supposed to give something or to be in a business relation as soon as the war is engaged with your enemies, right? So in that case, contract becomes impossible to perform, and so it is said that due to outbreak of war between the nations, the contract has become impossible. Change or amendments in law. I have engaged with a person for selling of an article A, okay, on 25th of August. At that time, buying and selling of article A was totally valid as per law. But when I had to deliver that to be after 1 month, say on 25th September, at that time or before 2 days, there was a law which says that selling and buying of article A or storing of article A has become punishable by law. So now the contract had already taken place, and now since storing, buying, selling all has become punishable by law, and if I am selling it, I will be punished. So by law, due to an amendment in the law, the contract has become impossible to perform. So I had given you an example of each one of these conditions. I hope it's clear now. Discharge by lapse of time. Time is very significant while entering into a contract. According to Limitation Act, contracts should be performed within a specified time called period of limitation. If in the contract it is not specified that in this particular span of time this contract needs to be terminated, then too it is the obligation of both the parties to take upon them to understand by themselves that there is a reasonable span of time within which they have to perform their duties, and within that reasonable time will only be the limitation period of time. So like if I had in festivals in India, there is a huge supply or a huge demand for sweets, right? So if a person A has contracted to person B for certain milk products, with which A is gonna make sweets for the sale in festival. Okay, festival is to come on Diwali. A has said to B that you send me 100 kg, let's suppose 100 kg of milk products, so that I will be making sweets out of them, and then my sale will be very good in the upcoming festive season. Now a reasonable man will understand that in coming 1 month or in next month there is a huge festive season, say Diwali, and maybe that since A is a sweet shop owner and he is asking me for 100 kg and he wants to make a good sale, that means he will be selling the products in Diwali. So a prudent man will be apprehending this, and he will be sending the product, this required product, within a reasonable period of time so that it can be utilized in the festive season. Not that if Diwali is to fall in November, B is sending the products in January next year. So now the reasonable time has lapsed. If A has specified that you have to supply it within 15 days, it was well and good, it was specified. But even if the time is not specified, then prudent man has to apprehend that what could be the reasonable period of time within which I have to perform my duty. Okay, he has to keep this thing in mind that within 1 month or in the upcoming month only there is a huge festive season. It may happen that A is asking such a huge amount of product for making sweets for that season only. So now if it hasn't happened, if B is delivering after December also, then A can say I am terminating this contract because now time has passed. Okay, contract has not taken place within the reasonable period of time, and so now I am Now I'm discharging, terminating this. If contract is not performed within specified time, another party does not resort to any action within the limitation period, then he is deprived of his remedy and contract gets discharged by lapse of time. Okay, so what is this mentioned, that if contract is not happening within the certain specified period of time, then the other party is not taking up any action within the limitation time for his remedy or to perform his duty, then he will be deprived of the compensation or the remedy that should be awarded to him, and so contract gets terminated automatically due to lapse of time. Discharge by operation of law. Following instances where a contract gets discharged by operation of law. Death of either party is insolvency means bankrupt. पैसे ही नहीं है, दिवाला निकल गया जिसको बोलते हैं हिंदी में. Merger. Unauthorized alteration of terms of agreement. Unauthorized means there was no mutual consent involved. Death of either party. दो पार्टी थी, उसमें से एक पार्टी मर गई तो ख़त्म ही हो गया ना. Discharge by breach of contract. Breach means to violate. Okay, breach means failure to perform the obligation by a party. When a party to contract does not perform his part of obligation, due to which contract becomes broken, person who suffers because of breach is entitled to receive compensation or damages from the party who has breached the contract. Now this section 73, which किसका सेक्शन है ये, किस एक्ट का, आईपीसी का, सीआरपीसी का, किसका, कॉन्स्टिट्यूशन का या आईसीए का? दिस इज ऑफ इंडियन कॉन्ट्रैक्ट एक्ट. एंड रिमेंबर, इफ समबडी इज गिविंग यू सच एब्सर्ड ऑप्शंस, सबसे एब्सर्ड इसमें है कॉन्स्टिट्यूशन. देयर आर आर्टिकल्स इन कॉन्स्टिट्यूशन. कॉन्स्टिट्यूशन डज नॉट कंटेन्स sections. Okay, so remember section 73, these are all of Indian Contract Act, year 1872. ठीक है. So हाँ, the person who has breached the contract is now obliged to give compensation to the person, to the other party involved in the contract, because there was no mistake of the other party, right? You were not able to perform the contract, because of which the contract is now broken, so you have to pay compensation to the other party. A agrees to supply 20 liters of oil to B on 1st June. On 1st June, A does not supply the oil. Then A has breached the contract. Suppose A has supplied oil but B does not accept it. Then B has breached it. In first instance, B is entitled to receive compensation from A. In latter, vice versa. Now damages. Damages is compensation only. Okay, damages means remedy. Remedy is a means given by law for enforcement of right of a person. As it happened over here, the person was receiving compensation, so that same is known as damage or remedy. A common remedy is awarding damages to affected party. Monetary compensation given to affected party for loss or injury caused to him due to breach is called damages. Monetary means in terms of a certain amount of money is provided by discretion of court, whatever the court may consider appropriate, whichever amount of money, that amount of money is provided to the affected party by the other party to the contract because of the loss or injury caused to him. The objective by court is to put injured party in same position as he would have been if contract had not breached. This under the contract law is called doctrine of restitution. So please remember what is doctrine of restitution. Paying monetary compensation or damages to the person, to the affected party for the loss or injury caused to him due to the breach of contract. So remember what is doctrine of restitution, where it is mentioned in the Indian Contract Act. The basis of this doctrine is awarding damages for pecuniary loss incurred by party to the contract. Pecuniary means anything related to money. Monetary amount is pecuniary. Now, what does this statement mean? Let me tell you that to put the injured party in the same position as he would have been if contract had taken place. So, let's say for this, A and B are two persons. If the contract had taken place, A would have got rupees 1000 and B would have got rupees 2000. Okay, let's suppose. But due to some conditions, contract was breached from side of B. B की side से contract breach हुआ. Now A, who was entitled to get rupees 1000 from B, after the breach of contract he will get 0. I'm not talking about B right now because breach इसने किया है तो मतलब A ने तो pay किया ही होगा, ठीक है. So now you can say that A had got rupees 0. Also he has given rupees 2000. So he has this thing, right? एक तो उसको मिला 0 और 2000 और निकल गया उसका. बात समझ में आ रही है? Now A will go to court. Court will say that to bring them to the same position or to the position where they would have been if contract had taken place, B has to give rupees 1000 as compensation to A. Okay? So now what will happen? This 0 minus 2k will become 0 minus 2k plus k because 1000 will be provided. So now he will be having 1k with him. He will be having 1k with him. Okay, so in exchange of 2000 money, the 1000 that A has to get, now he has it, and so this is the condition where they have been if the contract had taken place. So they have brought to the same position, and that's why this statement was given. Illustration is A agrees to deliver 40 bags of rice to B for rupees 20,000. On 15th July, A delivers only 20 bags of rice. B is entitled for damages from A for loss that he suffered because of A, because the rest